All right, let's go back over here, chat. Cutthroat Radio Podcast. This is, we were really looking at the first lawsuit, what Fat Joe filed, defamation and intentional infliction of emotional distress against Terrence Dixon and Tyrone Blackburn. But when we pulled up the docket to look for some exhibits, there was some stuff filed on Monday. so so now we're looking at all of that. And this one might be a little bit longer, you guys. This memorandum in support. This is where the beef would be. So 23 pages. Let's just do it, chat. Let's just do this. Let me save this real quick so that I can drop it in the folder later. And this was 23. This was filed. Blackburn motion to dismiss. Like, he's already tried to do a motion to dismiss in the letter. Guys. So June 23rd. So Monday we have this. By Tyrone Blackburn. Got a table of contents. We have some case law coming in. That's good to see. Let's see. I feel like he has a lot more text crammed on page than I'm used to seeing. Preliminary statement. So we've got a preliminary statement that this case must be dismissed because it fails as a matter of law under Federal Rules of Civil Procedure 12b-6, 8a, and 9b. Plaintiff Joseph Cartagena, also known as Fat Joe, is a Grammy-nominated public figure who filed this lawsuit as retaliation after defendant Dixon exercised their right to speak out regarding allegations of exploitation, fraud, and abuse. The complaint is nothing more than a constitutionally impermissible effort to silence criticism through aggressive and meritless litigation. The claims are legally deficient in several ways. First, the defamation claim fails because plaintiff, undisputedly a public figure, has not alleged any facts showing actual malice, as required under New York Times Co. v. Sullivan. In that landmark decision, the Supreme Court held that defamation is not a strict liability tort, and that public figure plaintiffs must establish, by clear and convincing evidence, that the allegedly defamatory statement was made with actual malice, that is, with knowledge of its falsity or reckless disregard for its truth. Plaintiff fails to do so. Second, the intentional infliction of emotional distress, IIED claim, is both duplicative and independently deficient. It is well settled that defamatory statements generally cannot constitute the extreme and outrageous behavior required for an intentional infliction of emotional distress claim. New York courts routinely dismiss IIED claims when the underlying allegations are already actionable under traditional tort theories such as defamation. Courts have consistently held that emotional distress stemming from defamatory speech must be addressed within the confines of a libel claim, not through IIED. Now, again, we talked about this, and I'm going to clip this part out, you guys, if you just want to look at this document. So if you're watching that clip, we talked about this in the full stream. The IIED claim relates to the request for money. So this argument doesn't address why the cause of action, the second cause of action in Cartagena's complaint, was filed and the allegations it's relying on for it to be an intentional infliction of emotional distress claim. This is the second document now that we're looking at where Blackburn is misframing it, as if it's just, he defamed me and it caused me emotional distress. No, he tried to ask me for money in relation to things that he wanted to claim. And that back and forth is what's being alleged to be intentional infliction of emotional distress. The defamation stuff didn't even involve Blackburn, but the second cause of action names both Blackburn and Dixon, separate things. And Blackburn's not addressing that. He's misframing what was being raised as this IIED claim. Moreover, even if considered independently, plaintiff's IIED claim fails on its merits. To prevail, a plaintiff must establish 4 elements. 1, extreme and outrageous conduct. 2, intent to cause or reckless disregard for a substantial probability of causing severe emotional distress. We got those things alleged. We had we had him lay out in this cause of action that it was outrageous. I'm pretty sure we got references to judges' characterization of other activities by Blackburn. Like, this stuff wasn't lacking in the filing. A causal connection between the conduct and the injury, something that a judge has admonished Tyrone Blackburn for not accomplishing. And 4, severe emotional distress. Courts evaluating such claims typically focus on the first element, whether the conduct alleged is so outrageous as to go beyond all bounds of decency. Here, plaintiff identifies nothing more than social media accusations and litigation threats. So now we're actually bringing in the litigation threats. We're finally acknowledging that as being part of these claims, which contradicts the argument made in this paragraph. These are not even close to the type of conduct deemed sufficiently outrageous under New York law. And he cites Howell, noting that the standard for IIED is rigorous and difficult to satisfy. Third, plaintiff's allegations lack the specificity and plausibility required by Rules 8A and 9B. The complaint is replete with conclusory allegations, speculative inferences, and irrelevant material. Interesting, because this is some of the same language that Judge Otkin used to characterize Tyrone Blackburn's filings in the Little Rod case. So that's interesting. I'm like, these words seem familiar. It reads as a retaliatory narrative aimed at discrediting defendant Dixon and his attorney, Tyrone Blackburn, not as a good faith effort to seek judicial redress. Let's just make sure this is only, he said by Tyrone Blackburn at the top here. By Tyrone Blackburn. And only Tyrone Blackburn. So just double checking. That's the only party writing this complaint. Where were we? In fact, the context surrounding this case, including Dixon's parallel lawsuit filed on June 19th, 2025 against Cartagena, confirms the context, including the case we filed. So the case is helping us confirm that the statements at issue arose directly in response to serious allegations of trafficking, labor exploitation, and sexual abuse, many of which are supported by detailed factual assertions, corroborating witness statements, and documentary evidence. Now, what's the problem here? He's not addressing the time period before that final week of April where we get the introduction of these allegations of trafficking. And hey, if you don't pay us, we're going to file this complaint. Here's a draft of it, and it's going to allege these things. We don't have that when this initial demand for money was being made the preceding month. And Blackburn's skipping over that. Skipping over it and saying that the statements at issue arose directly in response to serious allegations of trafficking. No, this came in mid-step after you upped the ante. So it goes on. It says Dixon's complaint filed in good faith. That's a nice little insert there. Just let the court know. Includes well-supported RICO and TVPA claims, which are now pending in this very district before this very court. Plaintiff's attempt to retaliate against that filing by rebranding it as defamation and IIED should not be entertained by this court. The complaint must be dismissed with prejudice. Legal standards. Under Federal Rule of Civil Procedure 12b-6, a complaint must be dismissed if it fails to state a claim upon which relief can be granted. To survive dismissal, a plaintiff must plead a plausible set of facts sufficient to raise a right to relief above the speculative level. A pleading that merely offers labels and conclusions or a formulaic recitation of the elements of a cause of action will not do. Nor is it enough for a plaintiff to allege facts that are merely consistent with liability. The facts alleged must nudge a claim across the line from conceivable to plausible. Federal Rules of Civil Procedure 882 requires a short and plain statement of the claim showing that the pleader is entitled to relief. This rule demands clarity and coherence. Complaints that are vague, sprawling, or filled with speculative assertions do not provide fair notice to the defendant and violate Rule 8. Speaking of vague filings, speculative assertions, something that he got yelled at for, Tyrone Blackburn got yelled at for, do not provide fair notice to the defendant and violate Rule 8. But we had specific screenshots of the examples, right? These are the Instagram posts. These are the posts on Threads. This is an Instagram story. This is what was contained in the caption and the image or the video. Here's the text of it. So that's not really vague. That's not vague. That's saying exactly what we're taking issue with. And guys, there's a good chance that this is pulled from a template, right? Oh, I have to write a motion to dismiss, and here's a template we have, and just swap out what you need. But here it's like we're not making the case law match what we're asking a motion to dismiss to happen on. Federal Rule of Civil Procedure 9b requires that in alleging fraud or mistake, a party must state with particularity circumstances constituting fraud or mistake. Although conditions of mind, such as malice or intent, may be averred generally, the underlying circumstances must be alleged with specificity. I mean, we have these exact screenshots. It's very specific. It's the words, it's pictures of the words. Courts in this circuit have applied Rule 9b not only to formal fraud claims, but to claims that are sound in fraud, including those based on allegations of deceit, extortion, or fabricated pretext. As explained below, plaintiff's claim fails under all three rules. His complaint lacks plausibility under Rule 12b6, fails to provide a coherent or concise narrative under Rule 8a, and fails to allege with particularity the factual basis for accusations of extortion, malice, or deception under Rule 9b. So, I mean, argument. Argument 1. The defamation claim should be dismissed under Rule 12b6. To state a claim for defamation under New York law, a plaintiff must allege a false statement of fact, 2, published to a third party without privilege or authorization, 3, with the requisite level of fault, and 4, that causes harm unless the statement is defamatory per se, in which case harm is presumed. Where the plaintiff is a public figure, the requisite level of fault is actual malice, meaning the plaintiff must ultimately prove the statement was made with knowledge of its falsity or with reckless disregard for the truth. Moreover, a public figure must plead sufficient facts to make it at least plausible that this demanding standard could be met. And remember, we had that fact that, and it was something that Dixon should be aware of for the defamation. The defamation cause of action is only against Dixon. The Dixon was making posts in relation to this Wisconsin incident where somebody made a complaint of sexual assault taking place, and headlines had Fat Joe concert in the title, but the complaint, according to Cartagena, according to Fat Joe, the complaining witness made the complaint to police about Dixon. Dixon was the one that engaged in the act. So by default, Dixon would have knowledge. Dixon would have the knowledge beforehand, before he would represent that headline, and then go on further than the headline to say Fat Joe did sexually assault somebody in Wisconsin. You had firsthand knowledge of that. So by default, if it's false and you're saying it, you would know of its falsity because you're the one with the firsthand knowledge. And this was in the complaint, so I don't see this argument working. Plaintiff Cartagena is unquestionably a public figure. He is described in his complaint and in the press as a famous rapper since the 1990s and a legend, in quotes, in his genre. Thus, to avoid dismissal, he must have alleged facts that, if true, would allow a reasonable inference that defendants made the challenge statements with actual malice. That is a really high standard, you guys. I'm not trying to minimize this standard, but what my gripe here is, they haven't alleged it. They haven't alleged it. They're ignoring he's a public figure. No, they've said it. He made the statements knowing they were false. So this argument doesn't seem to apply. It's like we're talking about a different pleading. As shown below, he has not done so. Additionally, many of the statements at issue are not actionable as defamation because they are protected opinions, rhetorical hyperbole. I hope Tasha K covers this. They're protected opinions, rhetorical hyperbole, or otherwise not plausible assertions of fact. Finally, the complaint fails to adequately plead the element of falsity with the required specificity and plausibility. Any one of these defects warrants dismissal of the defamation count. Together, they leave the claim utterly deficient. Argument A, Plaintiff's defamation claim fails as a matter of law. So plaintiff fails to plead actual malice, which is required because he's a public figure. Let's see. Yep, so they're going to say, I don't want this stream to go extremely long, but they're saying here, there's no doubt he's a public figure. I don't think Takapina and company are disputing that. But the issue, according to Blackburn, is that rather than allege any concrete facts showing that defendant knew the statements were false or entertained serious doubts as to their truth, plaintiff relies exclusively on vague, conclusory assertions that the statements were fabricated, malicious, and part of a broader extortion scheme. These allegations are devoid of specific factual support. For example, the complaint fails to identify any contemporaneous communication, contemporaneous, but they did identify the issue with the Wisconsin article that Dixon went back and was posting screenshots of headlines for, or other material that would plausibly suggest that defendants knew the statements were false at the time of publication. There is no reference to any witness recantations, discredited sources, or admissions by defendants. Plaintiff does not even allege that he informed defendants before publication that the statements were false. Such boilerplate accusations are patently insufficient. Courts in this circuit and across the country, wouldn't it be crazy if he cites himself? Across the country have repeatedly made clear that a public figure must allege more than mere disagreement or reputational harm. He must present well-pleaded, fact-specific allegations that demonstrate a plausible inference of actual malice. And they cite Bureau v. Condé Nast, affirming dismissal because the plaintiff failed to plead sufficient facts to give rise to a plausible inference of actual malice. Actual malice, this is all just the legal stuff, you guys. Actual malice is a subjective standard requiring proof that a statement was made with knowledge that it was false or with reckless disregard of whether it was false or not. I mean, we left some of this out in some of the argument above. Reckless disregard of the truth is a term of art requiring sufficient evidence to permit the conclusion that the defendant in fact entertained serious doubts as to the truth of this publication, and yet published with such doubts. Let's see. The Supreme Court has further cautioned that actual malice should not be confused with the concept of malice as an evil intent or a motive arising from spite or ill will. The governing standard focuses not on the defendant's attitude towards plaintiff, but rather on the defendant's attitude towards the truth. Because actual malice is a subjective standard, mere negligence does not suffice to prove a claim. The failure to investigate before publishing, even when a reasonably prudent person would have done so, is not sufficient to establish reckless disregard. But the issue here is that at least one of the claims involves something that Dixon either undoubtedly has firsthand knowledge of, or he was claiming to have firsthand knowledge of. So the in-between of being able to research something that somebody else has claimed somewhere and verifying before you republish it isn't at play for the majority, well, maybe not the majority, but for more than one example that was given in the initial filing. Those things were sourced back to Dixon as the originator of the claim or something that he would have firsthand knowledge of. So this doesn't absolve those examples. So let's see. The Second Circuit reaffirmed these principles, holding that actual malice requires that the complaint plausibly allege that the defendant published the defamatory statements with knowledge that they were false or with reckless disregard of whether they were false or not. The court emphasized that the reckless conduct needed to show actual malice is not measured by whether a reasonably... So this is all just supporting case law, you guys. From the right circuit, this is the Second Circuit. Actual malice can be shown through the defendant's own actions or statements, the dubious nature of his sources, well, if the source is maybe himself, and the inherent improbability of the story, among other circumstantial evidence. This, to me, actually supports Cartagena more here. The Second Circuit has emphasized that the actual malice standard imposes a heavy burden to proof, a burden that is designed to assure to the freedoms of speech and press that breathing space essential to their fruitful exercise. Yeah, I support free speech, right? But if you're claiming that this Wisconsin incident, Fat Joe was accused of sexual assault knowing that you were the one that had a complaint against you, and it just happened to be a Fat Joe concert, That's not really what free speech protects, my guy. So here, and I see Tat Calls and FFS have entered the chat. Good to see you guys. Boops to you both. Good boops. Um, let's see. Yeah, we know he's a public figure. In reality, the record before this court demonstrates the opposite. Defendant Dixon's statements were not random attacks, but rather were direct responses to a documented and serious dispute memorialized in Dixon v. Cartagena. A civil. No! What? This RICO didn't even. The 2023 tweets. How were his 2023 and 2024 screenshots on Instagram, not tweets? How are those direct responses to what's being memorialized in the Dixon case as a civil RICO and TVPA filed on June 19th, 2025? Because we've also seen him argue previously that these screenshots, this content that Cartagena included in this defamation and intentional infliction of emotional distress suit were substantially different transactions than what's going on in this Dixon versus Cartagena case. It's different stuff. So the cases should stay separate and the second case should be allowed to continue. This contradicts what he's arguing in the letter in opposition to Cartagena's motion to stay and or dismiss and or consider the cases related. Now he's saying that it's separate. That these texts were actually about the civil RICO. The text and the civil RICO were all about the same dispute. You argued they were distinct in your letter. Which one is it? In that lawsuit, Dixon details a 16-year pattern of financial coercion, forced labor, and sexual manipulation perpetrated by plaintiff and his enterprise. The complaint includes corroborated witness accounts, financial evidence, audio recordings, and extensive factual detail. These allegations were not only made under penalty of perjury, but were first introduced in pre-litigation negotiations with the plaintiff's counsel, protected by the litigation privilege. Now, you notice what he's not saying. He's saying it was introduced in pre-litigation negotiations, but we're talking about messages at least stemming back to 2023. But this correspondence with Blackburn and attorneys for Fat Joe wasn't happening until end of February, March. And then we don't even get the mention of RICO until the final days of this April 4-day deadline. So he's glossing over all of that. That these allegations were not only made under penalty of perjury, these allegations of forced labor, sexual manipulation, perpetrated by plaintiff and his enterprise, so RICO claim. These allegations were not only made under penalty of perjury, but were first introduced in pre-litigation negotiations and are protected by the litigation privilege. Sure, maybe you can argue that for that 2-day window, but he's making this argument in relation to, all of this defamation stuff, all of these tweets and Instagram posts in 2023 and 2024. He's blurring the line here to make an argument. So thus, even if plaintiff could somehow survive the privilege barrier, parentheses he cannot, the public record fatally undermines any plausible inference of actual malice. Dixon's parallel litigation establishes that he held a genuine, subjectively honest belief in the truth of his assertions, negating the reckless disregard component of the Sullivan standard. Courts have routinely dismissed defamation claims under these circumstances, particularly where the speaker's statement reflects the same content presented in judicial filings, backed by documentation and firsthand observation. He cites a case here saying dismissing a public figure's claim where defendant's statements were supported by substantial sourcing and grounded in prior investigations. Where are the other investigations, even if ultimately unproven? We apparently have, and I'll wait to see how that plays out, but there's an allegation here that Tyrone Blackburn has made the representation that he didn't even watch the video he claimed to have of what Dixon was alleging Fat Joe and his enterprise engaged in. So we already have reason to suspect, and it's included in the first lawsuit. The attorney didn't do the investigation on the merits of the claims. In short, plaintiff's allegations fall woefully short of what is required to plead actual malice. The court is not required to credit bare assertions of malicious intent where the complaint fails to allege any supporting facts. The plaintiff cannot transform reputational embarrassment into a federal cause of action by simply declaring himself defamed. The First Amendment does not permit a public figure to use defamation law as a cudgel to silence uncomfortable or accusatory speech, especially when that speech arises from protected legal advocacy and detailed factual grievance. Plaintiff's failure to plausibly allege actual malice is dispositive, and his defamation claim must be dismissed with prejudice. B, many of the alleged statements are non-actionable opinions or rhetorical hyperbole. We had some of this argument in the preceding this here, I think. And we're going to skip through some of this case law. Again, I will put all the documents in the folders that are linked in the description when I get done with the stream. Usually they'd be there before, but we only found these during the stream. Even if in Hey, don't F with justice. Jennifer Roshan is the judge. Let me see. Let me double check her name. If I can see where I have Pacer open still. Or court listener. I think I'm actually in that window. So let me open another one, double check. I think it's Jennifer Roshan. Yep, Judge Jennifer L. Roshan. But good to see you. This has been this has been a good time. And then also, hey to Jazzy T, good to see you. Even if plaintiff had sufficiently pleaded malice, which he has not, his defamation claim must still be dismissed because the challenge statements are, as a matter of settled law, non-actionable expressions of opinion, rhetorical hyperbole, or statements protected by the litigation privilege. And maybe this will apply to specific certain statements. But and we're accusing him of illegal acts on Instagram posts, so I'm not really sure we can just call that rhetorical hyperbole. Or especially if there's some of the statements were I'm not playing. So that's an implication that you're serious and not speaking rhetorically. So I don't know. But again, this argument is that some or many of the statements. So I guess some of them could fall under this argument, you guys. Let's see. They were made on Instagram. Okay, so the argument is that Instagram is a digital platform known for informal, exaggerated, and often hyperbolic discourse. Defendant Dixon's remarks were posted amid a public dispute with a former collaborator and contemporaneous with allegations he formally raised in a pending federal RICO and TVPA lawsuit. This is interesting wording because he's saying contemporaneous as if the litigation was happening. But the contemporaneous really only applies to things he's now alleging. And the first time we ever had anything related to pre-litigation for was 2 days before this April 29th filing made by Cartagena. So interesting wording there. And remember, this judge has both cases in front of her to look at. So she'll be able to see the same thing and make her own conclusions there. Courts recognize that the social media context combined with ongoing legal proceedings. But these things were not made with ongoing legal proceedings. These social media posts are from 2023 and 2024, with a few in 2025. Shapes how reasonable readers interpret such speech. New York courts have long held that expressions of opinion, as opposed to assertions of fact, are deemed privileged, and no matter how offensive, cannot be the subject of an action for defamation. As the Court of Appeals reaffirmed, however pernicious an opinion may seem, we depend for its correction not on the conscience of judge judges and juries, but on the competition of other ideas. But there is no constitutional value in false statements of fact. Another case, a statement of opinion consisting of language that is loose, figurative, or hyperbolic and lacking a precise meaning. If you're saying you dated an underage girl named Nikki for 5 years and took, like, that's not loose or figurative or hyperbolic, is it? Is it lacking precision? We're going to argue it's not actionable here. Courts must look to the broader communicative setting to determine how a reasonable reader would construe a statement. Rather, how would you construe a statement of someone saying Fat Joe dated someone underage? They started dating when she was underage. He dated her for 5 years. Her name was Nikki. How would someone how would someone a reasonable reader interpret that? Oh, you're just joking. It's all made up. It's rhetorical. It's rhetorically speaking. I don't know how we get there. Hey to Valinda. Good to see you. Oh my goodness. Sabata, so what are your initial thoughts on this? Does Ty's presence instantly push you one way? Not really in other situations. I mean, there's been other cases that I looked at and, I read what was presented without even knowing the attorney's name behind it. But here, seeing that he's actually a named party is, square in my line of sight, right? So, and I'm not liking the arguments that I'm seeing. Like, half the time we're getting an argument that contradicts something he filed on the same day. The letter that we read earlier in the stream was also filed on June 23rd. And there's arguments there that contradict arguments being made here. So it just to me, it adds to what judges have said about Tyrone Blackburn and the way he proceeds to file litigation. It's to seek headlines. It's to get the exposure. It's vague. Things that attorneys shouldn't be doing, he's doing, or things that attorneys should know better than to do, he seemingly doesn't know better. So I don't think that this is kind of like confirming what I read over the weekend that judges have said about Tyrone Blackburn, and it's not helpful. It is not helpful. But here, he's a named party. So I think this is different than when he's just been an attorney for somebody. Here we have another attorney saying you are engaging in intentional infliction of emotional distress by trying to threaten litigation if we don't give you money, if my client doesn't give you money. So, but again, we'll see. We'll see. You never know. You never know what we'll see what this judge does. A lot more case law, you guys. In this case, references to plaintiff as a, quote, pedophile accusations that he was, quote, dating a minor, or suggestions that he, quote, took advantage of underage girls falls within the realm of fiery rhetoric. These comments, while offensive, are plainly subjective moral condemnations made in the course of public controversy. No, that's a pretty specific act. It's one thing to say somebody's creepy, or you think they behave inappropriately in certain settings with someone of a particular age. But it's another to say he is a pedophile. It's another to say he dated a minor. It's another to say he took advantage of. And you can't walk away now and say, well, when I said took advantage of, I just meant, I wanted to promote my show and get crowds to come out. So, maybe I was over the top in the way I invited them out. And I didn't mean the word take advantage to imply sexual activity. But we have this litigation now where that's exactly what's being asserted, that it was, he took sexual advantage of underage girls. So we can't walk this one back now because we have litigation honing out the claim with further precision. But they're saying they lack specificity, factual verifiability. I mean, this is funny. And objective grounding necessary to render them actionable as false statements of fact. Notice we don't have the quote about Nikki, a girl named Nikki that we dated for 5 years here, as an example. The Supreme Court's holding in Greenbelt which protected the word blackmail as non-defamatory in the context of public discourse, applies with equal force here. We'll see. I think this would be an interesting legal thing to see the judge decide, but you know. Moreover, plaintiff's claims are further undermined by the absolute litigation privilege. Many of the statements plaintiff challenges closely track or explicitly reference allegations made in Dixon's federal complaint. His June 19th, 2025 complaint, even though these social media posts are from years ago. Under New York law, statements made by parties, attorneys, and witnesses in the course of judicial or quasi-judicial proceedings are absolutely privileged if, by any view or under any circumstances, they are pertinent to the litigation. Well, it only became pertinent 2 days before this April 29th suit. I want to see how this goes. Yeah, to hold otherwise would impermissibly chill the exercise of First Amendment rights and the pursuit of judicial remedies. Chilling effect versus the impact of calling someone a pedophile. A defendant cannot be subjected to liability merely for echoing in a public forum the substance of allegations raised in a legitimate legal filing. That principle protects both advocacy and expressive freedom, especially in matters of public interest involving high-profile figures. Let's see. Accordingly, even if plaintiff had adequately pled falsity and actual malice, which he has not, he did. What? The defamation claim would still fail because the statements at issue are non-actionable as a matter of law under both constitutional and New York defamation standards. Am I missing this for real? Like, I swear we read this and we keep having Tyrone Blackburn say that he didn't plead falsity and actual malice. We got there. He said he knew they were false when he said them. But we'll see. C. Statements made in anticipation of litigation are protected by absolute or qualified privilege. We've kind of argued this already. So we're blurring the arguments again. Let's see. Let's get right. We'll skip the case law. Let's get right to what's relevant to this case. All right. So we're finishing off with if a complainant were to be subject to a liable action by the accused attorney, the effect in many instances might well be to deter the filing of legitimate charges. That rationale applies with equal force here. The challenge statements were issued by counsel in the context of active and imminent litigation and relate directly to the factual basis of the claims now before the court. They are not extrajudicial attacks or public smears. They are litigation-directed communications that fall squarely within the bounds of protected speech, with a 2-year gap. That wasn't even, with claims that weren't even part of the pre-litigation conversations until the second to last day. Accordingly, plaintiff's defamation claim is barred in its entirety by the doctrines of absolute privilege, or at minimum, qualified privilege must be dismissed. D. Plaintiff fails to allege falsity with the requisite plausibility. Even if plaintiff's defamation claim were viable, which it's not, his claim for intentional infliction of emotional distress must also be dismissed. Under New York law, the elements of IIED claims are, well, we went through this, but extreme and outrageous conduct, intent to cause or disregard of a substantial probability of causing severe emotional distress, a causal connection between the conduct and injury, and severe emotional distress. Let's see, we get a bunch of case law. Here, plaintiff fails to plead any facts that approach this demanding threshold. He alleges no physical confrontation, no sustained pattern of harassment, and no conduct that remotely approximates the level of outrageousness required under New York law. I mean, let's read this then. Maybe let's go back and read the case law. It's got to be rigorous and difficult to satisfy. The alleged conduct must be so outrageous and extreme as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized society. I mean, and he's jumping here with an argument that there's no physical confrontation, no sustained pattern of harassment. And I would disagree with that because we had a whole timeline of, March of 2023, May of 2023, texting people when Instagram wasn't getting a response. But physical confrontation isn't a requirement by this definition that we're citing above. And no conduct that remotely approximates the level of outrageousness required under New York law. The statements he complains of were posted in the context of a public dispute using expressive and hyperbolic language and were drawn mainly from allegations asserted in a federal court complaint. Drawn sounds like the federal court complaint existed before the posts were made. As such, they are not only protected as opinion and litigation related speech, but also fall far short of the kind of egregious conduct courts have found actionable under an IED theory. And personally, guys, I would love to see some type of case law that gives judges discretion to say, or backs up a judge's use of discretion to say, I get that there's litigation, but based on the timelines here, it looks like you only filed this as a way to try to cover up and protect yourself from defamation or IIED or extortion. So, moreover, plaintiff fails to allege any facts showing that he suffered severe emotional distress as a result of the statements. There is no medical documentation, no factual support for the alleged distress, and no connection plausibly drawn between the online statements and any actionable injury. I mean, I think the harm is presumed there when when if you don't do this, we're gonna start litigation against you with claims of sexual assault against minors. But we'll see this one argued. Maybe this is something that Cartagena wants to make an amended complaint and hash out a bit more. The absence of both outrageous conduct and concrete injury renders plaintiff's IED claim deficient as a matter of law. For instance, if Dixon alleged that plaintiff flew a 16-year-old girl across state lines for sexual purposes, plaintiff could rebut that with specific exculpatory facts, such as identifying his whereabouts during the alleged event, producing travel records. Yes, this would be as the case proceeds, or denying any connection to the individual at issue. Now, we'll see what they continue to write. But those social posts cited in the complaint do not give a date and time frame. So how is somebody supposed to rebut somebody's claim of something other than just by saying that's not true, that never happened? How can they get more particular and say, you know what, let me put up a flight record and my whereabouts for every second of my entire life? This is such an unreasonable argument because they weren't given a time frame to identify to dispute this fact. Or denying any connection to the individual at issue. I mean, I feel like we had a complete denial in the pleading, but okay. This is stressful, you guys. If Dixon claimed plaintiff had sexual contact with a minor in a particular city or during a tour, plaintiff could demonstrate impossibility or providing conflicting records. This seems like a reference to Jay-Z and Busby with the Jane Doe. Yet the complaint is devoid of any such rebuttal or contextual clarification. Rather than refute specific factual claims, plaintiff adopts a litigation strategy grounded in general denials and rhetorical indignation, which cannot meet the burden imposed by rhetorical pleading standards. This is contradictory to the preceding argument in this filing that my client was just making rhetorical or vague opinion statements. Now you're arguing that we should dismiss Cartagena's complaints because he had the opportunity to magically, with specificity, counter the claims being made, as if the claims being made against him contain the specific context. So which one is it? Were your client, Terrence Dixon's posts, were they specific, or were they just rhetorical opinions and nothing specific that could be, factually verified? Because this implication, the implication of what's being argued here, contradicts what we're arguing previously in B. Was it B? Yeah, B. This contradicts what we're arguing in B. But okay. Moreover, and again, he's not addressing specific screenshots one by one. He's using one example here. So I get that some arguments could apply to some examples, but this pretty much seems like a broad stroke. Sometimes everything's rhetorical, sometimes everything's specific, and Cartagena could have addressed it with specific exculpatory evidence. Moreover, to the extent the complaint seeks to attribute defamatory meaning to pre-litigation emails or settlement demands transmitted by defendant Blackburn, an attorney, such communications are. Now we're arguing that the complaint tried to attribute defamatory meaning to stuff that came from Blackburn. Blackburn wasn't named as a party in the defamation cause of action. I don't know why it matters, an attorney, I guess client privilege here. But the complaint, this never happened. The complaint wasn't saying Blackburn's communications were defamatory. Blackburn is named in the intentional infliction of emotional distress. So this is a weird argument. It says, moreover, to the extent the complaint seeks to attribute defamatory meaning to the pre-litigation emails or settlement demands transmitted by defendant Blackburn, an attorney, such communications are plainly protected by the qualified litigation privilege and are not considered defamatory publications under New York law. This wasn't argued in the complaint. Yeah, so April O'Neil's baby daddy, good to see you, says, or what if the complaining guy was the one that had the girl around him and he was around Chubby Joe? So I based on what's being represented in Cartagena's filing, the April 29th one, it seems like there's the incident, the Wisconsin incident, the complaint was actually against Terrence Dixon, which means Terrence Dixon would know that. He'd be the person to know that. So I don't know. That one, I'm excited to see how that plays out, because we haven't really seen that addressed so far in this motion to dismiss. The claim that it was actually Terrence Dixon that the complaint was made about in relation to the Wisconsin event. So, and Don't F with Justice says, was a CRD complaint filed? I have not seen any indication of such. It looks like just a bunch of texts looking for money, credit on songs, and that escalated to now litigation related to claims of sexual assault with minors, RICO. Just a hot mess. But we've seen like vague references in here that these issues have been discussed contemporaneously, but I don't know. Let's see. Plaintiff concedes in his own complaint that many of the statements were made directly to him or his legal counsel in the context of settlement negotiations or pre-suit discussions for IIED. That is not the same as trying to seek defamatory meaning to the communications about the statements that were made in 2023 and 2024. These communications are not actionable. Indeed, to hold otherwise would expose virtually every demand letter or pre-litigation threat to potential liability and chill legitimate legal advocacy. I don't think it would chill legitimate legal advocacy. It would chill whatever is going on here, which I'm not sure is legitimate legal advocacy. That means well. That's way that I'm open to changing my mind. And even if such privilege were not absolute in this context, plaintiff fails to plead facts that would overcome it. He does not allege that the statements were irrelevant, gratuitous, or made in bad faith. Taken together, the complaint falls far short of alleging falsity with the factual heft necessary to withstand a motion to dismiss. Plaintiff's approach, asserting the falsity of explosive accusations without addressing their substance, they said it wasn't true, is both procedurally inadequate, and there wasn't much substance there, right? They were vague, is both procedurally inadequate and substantively unpersuasive. The court need not and should not discredit naked denials as sufficient to state a claim. particularly where the stakes involve speech concerning public figures and matters of substantial public concern. Accordingly, for this reason as well, the defamation claim must be dismissed. And now we're going over to the IIED claim, the plaintiff's IIED claim is duplicative of his defamation claim. It isn't really. You made representations up here as if it was. But the principle of dismissal for duplication applies here. Let's see. Plaintiffs cannot press both direct and supervisory claims against a single defendant, with both claims premised on the same conduct. The conduct for the IIED is the introduction, if you don't give us a sum of money, this is our demand letter, we're going to claim this about you. We're going to start litigation. We're going to initiate litigation by filing this. There is a difference there. It's a different action. This is crazy. The courts have consistently held that when a supervisory liability claim is based on the same facts as an underlying direct claim, it is redundant and must be dismissed. Let's see. The IIED claim is barred as duplicative of the defamation claim. Under well-established New York law, a plaintiff may not bootstrap an otherwise deficient defamation claim into an intentional infliction of emotional distress claim based on the same facts. The facts are different. Courts have consistently held that where the alleged conduct forming the basis of the IIED claim is identical to the allegedly defamatory statements, the IIED claim must be dismissed as duplicative. Most recently, the First Department reaffirmed this rule in Reeves v. Associated Newspapers. They upheld that an IIED claim resting on the same core allegations as a defamation cause of action must be dismissed as a matter of law, but that's not what's happening here. The IIED is oh my gosh, I don't need to say it a third time. I think you guys get me. I think you can disagree with me, but I think you guys get what I'm saying. The same principle applies to declaratory judgment claims that merely duplicate a defamation theory under a different label. Let's see. Here, plaintiff's IIED claim is entirely derivative of his defamation allegations. He does not cite any distinct conduct. Yeah, well, that's where he brings in an entirely different party. He brings in Tyrone Blackburn and the Blackburn law firm. That's distinct conduct by different people from the alleged public statements that form the basis of his defamation claim. Indeed, the IIED claim merely recharacterizes those same statements, accusations posted on social media, and conveyed in legal correspondence. No, we have entire new ones, including conversations from like April 22nd, 23rd through the 28th as outrageous conduct. But New York courts have made clear that a plaintiff cannot circumvent the constitutional and common law limitations on defamation claims by simply relabeling them as emotional distress claims. So, nor can plaintiff rely on authorities like Fleischer and Birkenfield, which both underscore the high bar for actionable defamation or derivative emotional distress claims. In Fleischer, the court found the challenge statement to be a non-actionable opinion. And in Birkenfield, the court found that the plea allegation and allegatory defamatory statements were substantially identical, an alignment that is clearly lacking here. Wait, an alignment that's lacking? Maybe I'm reading this wrong. Maybe I'm reading that wrong. I would say an alignment that is clearly present here if that was my argument that they were substantially identical. But okay. Accordingly, plaintiff's IIED claim must be dismissed in its entirety as duplicative of his defamation cause of action and legally insufficient under controlling New York precedent. I would love, and I know this would never happen, right? Because it's attorneys maybe discussing things with their client, legal strategy. I would love to be a fly on the wall of like when attorneys get notice that a response or opposition has been filed. I would love to see their face as they read through it and respond to it. Let's see. Plaintiff fails to allege conduct that is extreme and outrageous as required by New York law. So we've gotten into some of that. Let's see. Yeah, I feel like we've already argued this. The high threshold of IIED claims has got to be so outrageous in character. That standard is not met here. Courts routinely dismiss IIED claims arising from allegations of false accusations, legal threats, or even retaliatory workplace conduct. Um, Wait, the example here is in Dreimer v. Zionist Org of America, the plaintiff's claim alleging anxiety in a cardiac event resulting from a pattern of harassment was still deemed legally insufficient. The court rejected an IED claim in Suarez v. Bakelchuk, where the conduct, although extremely offensive and bizarre, was not legally outrageous. Let's see. Likewise, in Flaherty v. Dixon, the court found that even where the plaintiff alleged defamatory statements that cost him employment and damaged his reputation, those actions did not meet the requisite standard for outrageousness under New York law. Well, I don't know what the claims were here, but we're expecting future damages too. Employment, brand deals. The litigation even threatens to bring in market, whatever the market something company was, as a party. So I don't know how we get around that part unless we just say it's not outrageous. The court emphasized that even if such statements are false, hurtful, or career-ending, they do not satisfy the strict legal requirements for IED. Also, big shout out to Flesh of the Gods here, hanging out, sending us good wishes. Yeah, so check out Flesh of the Gods. He's been covering the Ronnie Walker trial. I think you've been doing that earlier in the days, right? So it's not so late at night. But the Ronnie Walker trial, you'll see FFS over there hanging out. I think Tat's been over there. So that's been an interesting one to watch. And going through the witnesses quickly on that trial. I always love to see a trial where the witnesses move along. Because it's just so not what we're used to after a million days in the YSL trial. And a little bit with Karen Reed. Let's see. Indeed, the conduct plaintiff describes here, posts on Instagram and alleged threats of litigation, are routine in contentious public disputes, particularly where, as here, defendant Dixon has already filed a civil complaint. Already, as in 19th. The 19th of this month, filed a civil complaint asserting RICO and TVPA claims against plaintiff. Courts have consistently held that such conduct, even if emotionally distressing, is not actionable under the exacting standards of New York tort law. Let's see. In short, the statements and conduct alleged by plaintiff, public criticisms, social media accusations, and pre-litigation threats are paradigmatic examples of conduct that courts have repeatedly deemed insufficient to sustain an IED claim. As such, this cause of action must be dismissed as a matter of law. So really we're really only addressing, I mean, do we address the law firm? I mean, are we addressing why? Because again, the second cause of action, this IIED, is against Dixon, Blackburn, and the law firm. I don't really know if we've addressed, I don't know if we've addressed in this section why, if we do not find that it's covered by privilege or whatever, that it also would not meet the standards of something outrageous. We just kind of skipped addressing that for the other defendants, but okay. C, plaintiff fails to allege severe emotional distress. In addition to alleging extreme and outrageous conduct, a viable IED claim must plead severe and debilitating emotional distress, not merely anger, indignation, or generalized reputational harm. So, but when we talk about generalized reputational harm and something's inherently damaging, you know, you're claiming someone's a pedophile that dated a 15-year-old girl or whatever, we're kind of getting out of this or. A plaintiff must allege that the distress suffered was so serious that no reasonable person could be expected to endure it. I wouldn't want to endure being accused of being a pedophile. Courts consistently reject IED claims where the alleged emotional harm is vague, conclusory, or entirely derivative of reputational injuries. And again, I do think that this is an area where maybe we'll see an amendment to the complaint to hash out further, you know, more of the emotional damages. But I think they want to be careful with that, because if you allege certain things, like if you start saying, I have PTSD from the claims, now Well, we need you to substantiate your claim of having something that's diagnosable. So let's get your medical records, your therapy records. There's a discovery line that you don't want to cross either. And maybe Tyrone Blackburn wants to goad Fat Joe into going there. Moreover, as a public figure, plaintiff must meet the heightened burden of pleading actual malice with particularity. That is, he must allege facts showing that defendants either knew their statements were false or acted with reckless disregard for their truth. We've talked about this already. Let's see. A qualified privilege, such as the litigation privilege or the fair comment privilege, may only be overcome by showing of either actual malice or common law malice. To show actual malice, plaintiff must prove that defendants either knew the statements were false or published them while harboring serious doubts to their truth. And again, we have claims that Dixon would have first-person knowledge of. So, and also as far as an attorney who had a duty to investigate, saying that they didn't actually look at the video that they used in pre-litigation communications to say, we have a video that shows you doing this. Oh, well, what do you mean? Let's see the video. Well, I didn't actually watch it. We have an issue here with representations made by Blackburn as well. That I don't think just simply saying the plaintiff didn't allege anything with specificity. That's a pretty specific example. Reckless disregard is not simply a failure to investigate. It requires a high degree of awareness of probable falsity. Although actual malice is a subjective inquiry, courts may infer it from objective facts. Well, I think that might be a fact of dispute whether or not Tyrone Blackburn said that, right? Did he actually say, oh, I didn't actually watch that video? But if at this stage, if the judge assumes that that allegation is true for the sake of this stage, then I think we've passed this bar. By contrast, common law malice focuses on the speaker's attitude towards the plaintiff rather than the truth of the statement. It requires proof that the defendant was motivated solely by spite or ill will. As the Second Circuit explained in Konikoff v. Prudential Insurance, the critical difference between the two forms of malice is that actual malice targets truthfulness, while common law malice targets the speaker's animus towards the plaintiff. Here, plaintiff offers no factual allegations beyond conclusory invocations of malice. I don't know, are we misrepresenting what factual allegations means? And I say this, like, oftentimes when a celebrity has a major lawsuit against them or they're filing one, a lot of people get introduced to their interest in like law news, legal news, because of a celebrity story, and they have to learn as they go. Like this stuff, if you don't know what things mean, you got to look it up. There's a lot to digest. And one of the things I see often is people will read a complaint, a lawsuit that's filed, the initial thing that opens a case, and that header that says factual allegations. People will take quotes from the factual allegations and assume factual to mean it's been proven. It already has been proven and hashed out. The court has found that this was proven, but it's at that stage, it's just an allegation of facts. Even when it's a statement of facts, these are the statements of the facts that I'm alleging when I'm bringing this suit against somebody else. But in common language, it's incorrectly interpreted to mean everything that follows is a proven fact, when really it's the facts that are likely going to be at dispute until, the case plays out. So, but here it seems like we're being wishy-washy with what factual allegations mean. He's saying plaintiff offers no factual allegations. There were allegations. We have this language beyond conclusory invocations of malice. This seems like the argument is it's not a proven fact, so that's not enough. And that's just an incorrect argument to make. That would plausibly support either standard. There are no well-pled, and now we're going to well-pled facts, showing that defendants entertained serious doubts about the veracity of their statements, nor are there allegations establishing that defendant acted solely out of spite. Indeed, the challenge statements arise in connection with sworn legal proceedings and personal experiences recounted in connection with a broader pattern of alleged misconduct. Without more, plaintiff fails to meet either the constitutional or common law thresholds required to overcome privilege or sustain an IIED claim. Plaintiff's complaint is silent on this requirement. He does not claim to have suffered psychological breakdowns, sought mental health treatment, been diagnosed with the condition, or experienced any lasting functional impairment. Instead, he vaguely alleges that the statements cause emotional distress. And again, I think we could amend this and add more in. Um, and maybe Blackburn wants that because he wants to be able to challenge specific claims, such as some type of diagnosis. In sum, plaintiff's IAED claim is both procedurally barred as duplicative and substantively deficient under the controlling case law. It should be dismissed with prejudice. And then argument three. The complaint should be dismissed under Rule 8 and 9b for failure to plead with sufficient clarity and particularity. So, a bunch of case law here. It's required that a complaint contains a short and plain statement of the claim, showing that the pleader is entitled to relief. Rule 8 is violated when a complaint is vague, conclusory, or so disorganized that it fails to provide defendants with fair notice of the claims. I mean, I thought it was pretty specific. I don't think it was disorganized. I don't I don't really think it was necessarily conclusory of what specific was being presented. Although there were conclusions that, my client never did these things, therefore this is false. The specific statement is false. So we'll see. We'll see. The complaint here fails to clearly identify which statements are alleged to be false, why they are false, and how each defendant individually is liable. The allegations are riddled with vague references to, quote, harassment, malicious intent, and defamatory conduct without linking such phrases to actual verifiable events. How many dates with timestamps did we see in the complaint, you guys? Like, oh my goodness. Oh my goodness. And also, thank you so much, Flesh of the Gods, gifting a membership. I'm looking over here for insights from the chat and I see some awesome green. So big thank you, Flesh of the Gods, supporting the channel, making some green out there. Like, this is just like, I don't know. Maybe I'm misreading. Maybe I imagined that we had timestamps and specific days, dates, the time someone emailed me, the day someone called me, what they did before and after that correspondence, what the next correspondence was. That's not vague. That's a timeline. Finally, beyond the substantive deficiencies of each cause of action, the complaint as a whole should be dismissed for failing to comply with fundamental pleading rules. Rule 8 requires a short, plain, and plausible statement of the claim. Oh, so you mean like 20 something pages instead of 158? As discussed above, plaintiff's pleading is anything but short or plain. It is a sprawling narrative that drags. Why are we mentioning other suits? It is a sprawling narrative that drags in the extraneous matter. For example, references to other lawsuits and third parties like Desiree Perez and Rock Nation in an apparent attempt to suggest a conspiracy without any coherent factual link to the case at bar. These side allegations do not belong in a well-pleaded complaint and highlight. Did I miss that? Did he call out that specific lawsuit in the... Hold on now. Like, this is the Joe Taka. Is he getting confused? Because what we're reading is a motion to dismiss this April 29th complaint. And I can search this document. Like, I'll search for Cartagena. That's coming up. I don't see Desiree. I don't see Perez. Let's do Nation instead of Rock, because maybe I don't see... I have National League. I don't see Nation. We just have National League. I don't have ROC. I don't have ROC. Are we lost? Are we lost, chat? Oh my goodness. I'm actually lost. I don't know which tab I was in. Let me find our way back. Is it this? Okay, I think it's not loading anymore. I might let me reopen it. There we go. Okay. Am I lost? As discussed above, plaintiff's pleading. Plaintiff here, this is the April 29th, is anything but short or plain. It is a sprawling narrative that drags in the extraneous matter. For example, references to other lawsuits and third parties like Desiree Perez and Rock Nation. These are in quotes, in an apparent attempt to suggest a conspiracy without any coherent factual link to the case at bar. Was there, I mean, this has all been about the complaint. We haven't heard a second amended, we haven't heard an amended complaint. Okay, hold on. Is there an amended complaint? There's more, guys. Let's see. Well, this is just the order. Let's see if there's anything else attached here. Order. We don't want that one. And then this would be the complaint. Okay. We'll download this. It says 25 pages, so I don't think it's that much longer. Let's see. And hold on, let me get this in Google Drive so we can open it on stream. Let me rename it. So if you guys want to go and look at this, FAC for first amended complaint. So let's see. Where do we get this? Okay, it's searchable, but I'm not getting Desiree. I'm not getting Perez. Unless I downloaded the wrong one. No, filed May 1st. Is there... I don't see a mention of the word conspiracy. Let's try Nation. We just have the National League. Is there anything else on anything else? Amended complaint. Oh, and the order says to allege the citizenship of each constituent. This is number 14. So even this service in May was that amended filing where we don't see a mention of Desiree. Where is this reference coming from, you guys? This is a little weird. I don't know what to make of that because I don't see what they're referencing, but it's being referenced in quotes here, so I don't know. So back to here. Plaintiff's pleading is anything but short or plain. It's a sprawling narrative that drags in the extraneous matter, for example, references to other lawsuits and third parties like Desiree Perez and Rock Nation, in an apparent attempt to suggest a conspiracy without any coherent factual link to the case at bar. These side allegations do not belong in a well-pleaded complaint and highlight its implausible speculative nature. The inclusion of such material tends to confirm that the plaintiff is using this lawsuit to fight a broader battle or agenda rather than resolve a concrete legal inquiry. That is improper under Rule 8, which is designed to focus the litigation on specific actionable events. When one strips away the colorful but irrelevant commentary, one is left with a relatively simple dispute. Dixon made accusations, plaintiff says they are false. That could have been pleaded in a few paragraphs. Instead, we have a convoluted pleading that obscures the core facts and forces defendants and the court to sift the wheat from the chaff. Dismissal is warranted on this ground alone, with leave, perhaps, to replead in a coherent fashion. Although in this case, repleading would not cure the substantive problems identified in sections 1 and 2. So dismissal with prejudice is appropriate. And guys, before we move on to the next paragraph, I'm going to say I don't know what this is talking about. I don't know if there's another pleading that we're not seeing. And because they're referring to it as a pleading and the complaint, and plaintiff complaint, that means Cartagena's complaint. I don't know, maybe it's in the other lawsuit, but that wouldn't be the complaint. This is a motion to dismiss the complaint in Cartagena v. Dixon. So if you're raising an issue and saying it should be dismissed because of a failure to comply with the rules for the pleading, it would have to be applicable to the complaint made here in this case. I think they're just confused. I don't know. Oh my gosh. I didn't mean to like sit here stomped on stream, you guys. I was just trying to figure it out, but like I don't know what to make of that. I don't know what to make of that. Additionally, as noted, and yeah, I'm so confused. And it's one of those things where Desiree and Rock Nation, their names are being brought up in a bunch of cases. So I feel like, maybe I was missing a reference and I just overlooked it, but I just don't see it in the complaint at issue here or the amended complaint, which was apparently only updated to fix a jurisdiction issue for the law firm as a party. So additionally, as noted, and dismissal with prejudice is noted. So additionally, as noted, Rule 9b's particularity requirement applies to any allegations of fraudulent misrepresentation or deceit in the complaint. Plaintiff insinuates that defendants engage in a form of extortionate fraud, essentially that they fabricated heinous allegations to extort money from him. While plaintiff has not labeled a count fraud, this allegation pervades his narrative and even underpins the claim of malice. Such allegations must be pleaded with particularity. Here, plaintiff fails to identify with specificity any misrepresentation beyond the defamatory statements themselves, which we've addressed. If plaintiff means to allege that defendants falsely represented an intention to sue without actually planning to, or falsely representing that they had evidence when they did not, those are species of fraudulent inducement or false pretenses that require detail. Well, we had the specifics about the video that Tyrone Blackburn apparently represented that he had and would make public. And then, well, I haven't actually watched the video. That's pretty specific. And if you don't know which one we're talking about, then you either need to say that specific allegation in the complaint is meritless and untrue. You need to address that specifically. Or you don't know what video they're talking about, and that seems more like a you problem than an initial pleading problem. So, and I don't know, it's also weird to volunteer if plaintiff means to allege that defendants falsely represented an intention to sue without actually planning to. This kind of, I read between the lines, maybe this is why we're actually suing. Because remember, when you gave that 4-day window, you were suddenly sending a bunch of emails. Are you going to accept our demands yet? Are you going to accept our demands yet? Oh, you know what? Today's the final day. We're going to make it even worse. If you don't do it right now, we're going to also throw in RICO and TVPA claims. That kind of, this worry, you're volunteering this, right? You don't need to actually address this because this wasn't explicitly alleged of Tyrone Blackburn. But volunteering this makes it seem like maybe that is why we ended up with this June 19th complaint. So, not this. That's not what we're reading right now. This is the motion to dismiss, but I don't know. Yeah. Oh, and I think for always, forever, for life is a bit behind because she says, yes, people will assume that it's been proven. Yeah, it's like, I don't like to get annoyed when I see that because I understand why people would think that. So I just like to give everyone the grace, you know, hey, that's, in the legal context, when you see a statement of facts, it doesn't mean stuff that's proven it's beyond contest. You can't contest it anymore. Right. But when you have someone that's new, interested in the story, and they're reading stuff for the first time, I get why they take it that way. But it can be problematic because then a bunch of people are saying, well, it's been proven that, and that's really not what happened, but dozens, hundreds of people start thinking that. And because so many people are saying it, an outsider that didn't look at the document themselves or, be familiar with legal terms, they might say, well, so many people are saying it's true. And that's how we get this kind of like chaotic, uncontrollable reaction that leads to misinformation and misinterpretations on a broad scale. So, but when you catch up to us, hey, to pass for always, forever, for life. Let's see. So they say, let's see, plaintiff fails to identify with specificity any misrepresentation beyond the defamatory statements. If plaintiff means to allege that the defendants falsely represented an intention to sue without actually planning to, or falsely represented that they had evidence when they did not, those are species of fraudulent inducement of false pretenses that require detail. None is provided. Thus, to whatever extent plaintiff's claims rely on a fraudulent demand theory, they should be dismissed under Rule 9b. Moreover, as the Second Circuit explained in Bureau v. Nest, even though Rule 9b allows malice to be alleged generally, that does not save a public figure plaintiff from the obligation to plead a plausible factual basis for malice under Rule 8. What header are we under? It should be dismissed under Rules 8 and 9b for failure to plead with sufficient clarity and particularity. Let's see. This seems like a slightly different argument. Yeah, we're arguing 9b, which is included in the header. But although malice can be alleged generally, that does not save a public figure plaintiff from the obligation to plead a plausible factual basis for malice under Rule 8. The plaintiff's attempt to generally aver malice without facts fails, as discussed. In short, the pleading does not pass muster under Rule 8 or Rule 9b. Well, you kind of argued that it would under 9b, but you're saying it doesn't under 8. And now you're saying it's either. But I think, again, maybe amend it to get more specific. In sum, this complaint is an archetype of the kind of case that warrants dismissal at the threshold. It is legally insufficient in multiple independent respects and appears to be fueled by ulterior motives rather than a genuine belief in a viable claim. Allowing it to proceed without subject defendants to costly discovery and protracted litigation over what is, at its heart, an interpersonal feud and smear campaign, the sort of dispute that our courts vigilantly guard against turning into a federal case absent compelling circumstances. No such circumstances are present here. Is there something where a smear campaign is different than defamation? Let's see. Is there like a legal, I mean, we don't have case law here saying that a smear is not the same as defamation. Um, I don't know. This seems like this doesn't make sense to me. No such circumstances are present here, as this very court has emphasized. You know what else this court has emphasized about Tyrone Blackburn? Anyway, allegations of fraud or malice must be supported by concrete facts, not by conclusory assertions or narrative framing. In Halibut, the court denied the defendant's motion to dismiss an anti-slap-based claim where the defendant's defamation lawsuit was dismissed due to their failure to plausibly allege actual malice beyond conclusory speculation. The same deficiency applies here. Plaintiff's failure to plead falsity, intent, and personal knowledge of wrongdoing. He did plead personal knowledge. I think we've pled falsity, I think we've pled intent, and I think we've pled personal knowledge, and it's a issue of fact, I guess, not a deficient pleading, but that's my read. Again, I'm not the judge. Renders the complaint deficient under Rules 8 and 9b and warrants dismissal on those grounds alone. And then the complaint is barred by anti-SLAPP. So let's see. Here, plaintiff is a Grammy-nominated celebrity alleging reputational harm from public statements made in connection with litigation and public allegations of sexual abuse, labor exploitation, and trafficking. These are matters of indisputable public interest. The statements at issue were made by a former longtime associate, defendant Dixon. Are you going to say that he would have personal knowledge? I don't think we should argue that. On Instagram and in legal filings, which constitute public forums. Let's see, Abitbol v. Rice, social media qualifies as a public forum. A speech regarding public figures and alleged abuse falls within the statute. Further, the speech was made in connection with a civil RICO and TVPA lawsuit. In connection with a 2023 post in connection with a 2025 filing, which itself alleged systemic abuse and forced labor. Under settled law, speech related to legal proceedings and matters of social consequence constitutes protected speech. Definity found versus New York Times, affirming dismissal under anti-SLAPP law, where speech was part of a robust public debate on a matter of political, legal, and scientific importance. Now, we're getting a lot of New York Times cases cited here, but what's the difference? If New York Times is reporting on something, probably relying on information that they investigated through somebody else. But here, we're relying on things where the source of the accusation regarding situations where there would be firsthand knowledge from the person making the statements. There is no reporter in between that's relying on the word of somebody else. For Dixon, for the defamation, he's alleged things that he had firsthand knowledge of, that he says he had firsthand knowledge of, or reasonably would have had firsthand knowledge of. And for the IED, we have the attorney, the law firm, representing that we verified these things, and perhaps they didn't. So I don't think that's the same as the New York Times maybe investigating something but not enough, but they're relying on somebody else's word. And that is a very high bar to get around. I think there's a lot of protections there for these publications. But it's very distinct. It's very distinct from someone with firsthand knowledge. I was there, I witnessed it, I saw it. I know. Because I've been around him so long, I know. That's very different than a reporter reporting on something. So I don't know how this case compares, but okay. Plaintiff, as a public figure, cannot escape the requirement of alleging and ultimately proving actual malice by clear and convincing evidence. He has failed to do so. As explained above, the complaint is devoid of non-conclusory factual allegations, showing that defendants knew the challenged statements were false or recklessly disregarded their truth. At most, plaintiff claims the allegations were false and damaging, but that is not enough under New York Times v. Sullivan and his progeny. So moreover, the case of Halibut and Cassava reinforces this point. There, this very court dismissed defamation and fraud claims because the plaintiff failed to link any specific falsehood to any identified defendant. I don't think that's relevant here. And again, this is an issue that Tyrone Blackburn has had with his own filings, where he's not linking the action being accused, maybe not falsehoods, but the actions in general, to a specific defendant, a named defendant, or to plausibly allege actual malice beyond conclusory speculation. The same reasoning applies here. Plaintiff has not identified specific falsities or alleged actual malice in a non-speculative, plausible manner. Indeed, as in Halibut, the complaint's failure to isolate actionable statements from constitutionally protected opinion and legal advocacy is fatal. So maybe the judge will find that. In light of the above and consistent with the anti-SLAPP framework adopted in this district, plaintiff's complaint must be dismissed in its entirety. Furthermore, defendants intend to seek recovery of attorney's fees and costs permitted under the Civil Rights Law 70A1A. which allows prevailing defendants in anti-SLAPP proceedings to recover mandatory costs upon dismissal. So in conclusion, for the foregoing reasons, defendants Terrence Dixon, Tyrone Blackburn, and T.A. Blackburn Law respectfully request that the court dismiss the complaint in its entirety with prejudice according to the Federal Rules of Civil Procedure 12b6, 8a, and 9b. The plaintiff's claims are facially and fatally defective. He fails to plausibly allege actual malice as required for defamation claims by a public figure. The First Amendment protects the statements at issue as a non-actionable opinion, rhetorical hyperbole, or privileged litigation-related speech. The intentional infliction of emotional distress claim is duplicative and in any event does not allege conduct remotely approaching the extreme and outrageous standard required by New York law. Furthermore, the public complaint is rife with conclusory allegations, speculative insinuations, and irrelevant material that fails to meet even the minimal pleading standards of Rules 8 and 9b. In short, this lawsuit is not a good faith invocation of the judicial process, but an attempt to chill protected speech and retaliate against Dixon's and his counsel's legitimate legal claims. Well, what? I almost said Busby. Blackburn isn't making a claim. Blackburn isn't a plaintiff in the June 19th suit. So this is weird wording. But okay, allowing this case to proceed would subvert fundamental First Amendment protections and subject the judicial system to abuse. So it's like he's trying to extend anti-SLAPP to this IIED claim against himself, just because he's arguing that it would apply to Dixon. Accordingly, the complaint should be dismissed with prejudice and such other and further relief granted to defendants as court deems just and proper. So there you go. This was June 23rd. Tyrone Blackburn. That's where we are. I think that was like the final